Hello and good evening, I'm Melissa Idris.
And I'm Sharad Kuttan.
You're watching Consider This. Recently, the federal court, in a majority ruling, said that the National Registration Department, or the NRD, was wrong to decide on its own to use bin Abdullah for a Johor-born illegitimate Muslim child's name in his birth certificate. However, the federal court also said that the NRD was right to disallow the father's name to be part of the boy's name. Now, this was a majority decision with 4 of the 7 judges on the federal court panel for this case. The boy was born in 2009, but his birth was only registered 2 years later, and because he was born less than 6 months after the parents' marriage, that is considered illegitimate under Sharia law. Here to discuss the case a little bit further, we have Nizam Bashir, who was a lawyer representing the parents and the child in the bin Abdullah case. Nizam, welcome to the show.
Thank you.
All right, so I think I just want to get your perspective, or help us set the scene in terms of the recent ruling from the federal court. What was the significance of this allowing and then disallowing?
Well, I think perhaps it's best to firstly identify what was referred to the federal court for them to decide. Now, there were 3 questions that were referred to the federal court. Now, the first question was whether a particular section of the Births, Deaths Registration Act applies to the registration of births of Malay Muslim children. So that was the first question. Then the other question was whether the Registrar of Births may refer and rely on sources of Islamic law on legitimacy. And finally, whether the civil court can determine questions or matters of legitimacy of Muslim children in respect of naming and ascription of paternity. Now, the federal court did not answer all the questions. They only answered 2 out of 3. And vis-a-vis the first question, the federal court ruled that Section 13 of the Births, Deaths Registration Act, which deals with surnames, do not apply to registration of births of Malay Muslim children, as Malays do not have surnames. Okay, that's the broad position that the federal court arrived at. And vis-a-vis the second question, in performing registration of births of Muslim children, the Director General of the National Registration Department may refer to and rely on sources of Islamic law on legitimacy, but it has to be done in a lawful manner. So vis-a-vis the second question, the court did not agree that the registrar in question exercised his powers in a lawful manner. And the reason for that was because the child in question, it comes from Johor, and Johor does not have any state fatwa on the matter regulating the issue of naming of Muslim illegitimate children. So when the registrar was dealing with the application, he looked at the National Fatwa Committee's fatwa on the matter, which was never gazetted in Johor, and made a ruling that based on that, the child had to be bin Abdullah and could not be given a name bin the father's name.
Right.
I want to ask you, I mean, this is the kind of like stepping back from, you know, what seems to be a legal thicket of, you know, of fatwas and laws and reasons and, you know, and solid reasons for having those laws. I do want to ask this question, though, you know, whether at the end of the day, a child is named in order to signal who they belong to in a family sense, right? Sure. We know that there's no dispute about mothers.
Sure.
So legitimacy comes from, if legitimacy came from your mother, there'd be no problem.
Sure.
Right? So what is at stake here? And what should the public at least focus on when thinking about this issue? What is at stake here? Is this about private morality, or is it about the interests of the child?
I think on the one hand, there is a right to identity that is at stake, because as you rightly noted, at the end of the day, when you're talking about children, you're talking about family, it's a sense of identification with the family. And of course, you know, if there's only one child, it's not so problematic. But when you have more than one child, for example, the first child may be illegitimate, the second child may not be. And the second child has got a bin with the father's name, the first child doesn't. And the first child, maybe it's bin Abdullah, or maybe totally no bin, as perhaps has happened here. So that causes a problem. And I can be very candid in terms of the facts of, or in my client's case, he opted not to have a second child. for that very reason, because he didn't know how to explain to his child, if he had another child, that there was a different bin there.
That's an extraordinary
Yeah.
sacrifice family to make.
Can I just come back to your initial answer, Nizam, and get you to clarify? So you mentioned that because he is Johor born, that there's no fatwa that's been gazetted under this. Explain to me the role of the fatwa in determining the legitimacy of a child in the different states.
Yeah, I think if we were to look at the Birth That's Registration Act in the first place, there is no framework for that really, for the registrar to sort of look at other sources to determine naming rights. So if we were to look at the Act alone, as long as the name doesn't confer an objectionable meaning, an offensive meaning, the registrar is duty bound to register the name. So what has happened here, I suppose they sort of the registrar opted to look at things beyond perhaps the parameters of the Act, and that was why one of the questions was whether he could do that. And the court took the view in answering the question that he could do that, to look at Islamic law on matters of naming to determine that question as to whether or not the child could be named with the bin of the father's name.
Right.
Well, I want to ask you about, okay, just again, a very broad question, but Muslims and non-Muslims in this country, and the non-Muslim category, because it's a huge array of diversity. A lot of Indians don't have surnames like Malay Muslims too, and we know some Malay Muslims actually do have surnames. So is this a question that's a problem peculiar to the Muslim community of Malaysia? Or do non-Muslims ever get caught up in this question of legitimacy, which is a universal issue? Paternity is a universal one. Or is it just a peculiarly Malay Muslim problem?
Well, if we were to look at Section 13A, which addresses the question of naming of illegitimate children, Section 13A provides a mechanism to overcome this issue. So long as the father consents to it, there's a joint application between the father and mother, the child can be given the surname of the father.
Right, the father here, we mean somebody who's married to the mother, not necessarily the biological father. Would that be correct? Is there a need to establish the biological link between father and child?
I'm just going to look at the provisions of Section 13A. I don't think there's any restriction in that sense. As long as someone is prepared to come forward and say that, look, I'm the father of that child, that's the end of the matter.
Right.
Okay? And I think the registrar should not make any further inquiries. I think Section 13A is merciful in that sense, and I think we should maintain that approach, because at the end of the day, what are we trying to encourage? If individuals are prepared to come forward, be responsible for a child, for a family, shouldn't that be something that we encourage?
Right.
I think it's so simple.
All right, we're going to take a quick break and continue this conversation, particularly pick up on that point.
Sure.
Stay tuned to Consider This. Don't go anywhere. Welcome back to Consider This. Melissa and Sharad here with you tonight, speaking to Nizam Bashir, lawyer representing the parents and the child in the bin Abdullah case. Now, I want to ask you, Nizam, whether this is a particularly unique situation. I mean, are there many other Muslim parents who are fighting to name their illegitimate children after the father?
I think it's a significant problem for any community. I don't think it's necessarily unique to non-Muslims. I mean, I've had many phone calls from Muslim parents, and I think perhaps there is a bit more of hesitance to deal with the issue, because there's also perhaps the sort of religious backdrop to all of this.
Right.
And perhaps most parents are unsure how to deal with it, but they know what they want. Yeah? And what they want simply at the end of the day is the ability to give the child a fair go at living their life without being saddled with whatever mistakes they may have committed. Yeah? You know, most of the parents who call me, they are in tears and they are saying, look, we know the mistakes that we made, but punish us, don't punish the child. And I think that's perhaps why I said it was a very simple way of looking at it.
It's the compassion argument, and I know several muftis have come out to make that, or to kind of back that argument. But if you look at the public outcry around this, right, it's mixed. There are liberals who are outraged, and then there are others who are saying, no, this is good because it's important to establish public morality, or at least establish our moral standards on a public level. That any concession on this issue, even in the name of compassion, would be bad in terms of public policy you like, or in terms of the signal you're sending out. I mean, how do you respond to those arguments?
Quite simple, because ultimately you're trying to punish an innocent person, and that really is the biggest problem with this entire issue. Any sense of outrage one would feel is perhaps, whatever Sharia crime that may have been committed, was committed by perhaps the parents. But the child didn't do anything. He didn't ask to be born in this world. So why saddle him with something that's going to cause him, effectively either ridicule or problems in the world? People will know exactly what the child is.
Nizam, can you talk a little bit more about that? You talk about punishing the child. What is this complex issue of stigmatization of a Muslim child born out of wedlock in Malaysia?
I mean, a child who essentially is marked to be different in some way, in terms of his name, in terms of, what's on the birth certificate, will quite likely be treated differently by perhaps his teachers, by perhaps his friends in school, and parents, I think, faced with those concerns, may even opt not to send their child to a national school. They would prefer that the child has a bit more of a fair go in terms of education by sending the child to a Chinese school, for example, where people may not be so aware as to the differences in the names. Yeah, and you can understand that, because again, every parent who's committed whatever mistakes, they say, we made the mistake, but don't punish my child.
Where is the conversation happening? You've used the legal route, you've used the courts to try and find a remedy for a problem.
Yes.
But ultimately, is it a conversation that needs to happen outside the realm of law, that it needs to go to religious leaders, it needs to go to community leaders to have a conversation to shift the balance, as it were, in terms of where these decisions are being made? I mean, how do you move? Is it only the law?
Whenever cases like this are being filed, we're not trying to ensure that it is only resolved at one forum. Yeah, we're trying to encourage at the end of the day a conversation about where or how we should be looking at this issue. Yeah, and certainly you're right, Sharat. The conversation should be happening even with religious leaders on the matter. And look at Perlis, for example. Perlis has taken a different approach on this matter. The fatwa in Perlis actually says that parents can name the child with the bin of the father's name, despite the fact that the child is illegitimate. Yeah, so you can see that actually there seems to be some room for that even in Islamic law. And if there is room for that, then I think it's time for us to take a step back and consider what is it exactly that we're trying to inculcate within the Muslim community. And I come back to what I said earlier. Shouldn't the primary objective be, if someone is prepared to come forward, be responsible for a child, to care for the child, you allow that, encourage that. And the best way for that to happen is to allow the child to be named with the bin of the father's name, because he identifies, therefore, in the fullest sense of the word, that this is my father.
Are you using the traction from this recent ruling to perhaps have this conversation?
Well, I'm on Astro AWANI for that reason.
And we appreciate it.
and beyond that, I think even subsequent to the decision in the federal court, I was quite happy to see that Tuanku of Johor made a commandment that whatever the effect of the fatwa may be before, we have to be very careful not to implement it to such an extent that it shames the child and effectively prevents him from having a decent future. I was quite happy to see that, because I think that's a very compassionate approach to the issue. You're looking at the best interest of the child.
Where's the resistance coming from?
Well, I think, as you pointed out earlier, there's of course the morality argument. We don't want to also similarly encourage people to do things which are contrary to Islamic values. Certainly, if you talk about what it means to be within a family, being married, you certainly must ensure that you have relationships within the bounds of the marriage itself. So I think whatever outrage that comes, it's coming perhaps from that, the various Quranic verses on the matter as well, about essentially sexual ethics, etc. Yeah. So, but I still think, nevertheless, irrespective of whatever the concerns may be, we have ways to deal with each respectively. And what you're dealing ultimately with is a child who's innocent, who's not done anything. So why punish a child?
All right, we're going to take a quick break and come back and continue this conversation with Nizam Bashir, constitutional lawyer, right here on Consider This. Welcome back to Consider This. Melissa and Sharad here with you tonight, and we're speaking to Nizam Bashir, lawyer representing the parents and the child in the bin Abdullah case. As you may have heard, the federal court had a majority ruling last week. Now, 3 of the 7 judges on the federal court panel for this case dissented, and the 3 dissenting judges gave 2 separate judgments. I'm wondering, Nizam, if that is first of all, that's common that the 3 dissenting judges gave 2 separate judgments, and what were in these dissenting judgments that you found particularly interesting?
Sure. I don't think it's particularly common, especially to find a dissenting judgment written or 2 separate dissenting judgments. I think that's quite uncommon. But by the same token, I can understand why it happened, because I'm sure the facts that's involved in the matter that was at the federal court was compelling enough that it must have caused them to search their conscience and grapple with the issues that was raised for them to decide on. Let's look firstly at perhaps the what I found most compelling in Justice David Wong's minority dissenting judgment. Yeah. He focused on the right to equality, and also the fact that when in birth certificates, one of the complaints that we made was in the birth certificates, aside from the naming aspect that was argued in the federal court, there's a column at the bottom where there's a remark column where the registrar made a notation of Section 13 application. So that Section 13 application effectively informs the world that the child is illegitimate. And we, when we complained about that to the court, we basically said that, look, you shouldn't be telling everyone, all and sundry, that this child is illegitimate. Now, of course, there may be some stakeholders who may have some basis to know that the child is illegitimate. For example, the Sharia courts may want to know that the child is legitimate for purposes of marriage, etc. But there are ways to deal with that, because when you apply for permission to marry in the Sharia courts, there is a form. You've got to supply the marriage certificates of your parents, etc. And from there, you can tell very quickly whether the child is legitimate or otherwise. And there are consequences if the child is illegitimate. But for non-Sharia purposes, I certainly don't see any reason why that sort of information should be shared with the world. And that was the very same approach that Justice David Wong adopted in his minority judgment. And he basically said, his lordship basically said that, look, you can't share that information to all and sundry. For example, when you apply for your driving license, what business is it for the road transport department to know that the child is legitimate? There's no purpose.
There's a right to confidentiality too, isn't there?
Exactly. Yeah. So that's perhaps the principal ground that Justice David relied upon. There's also Justice Nalini's dissenting judgment, She looked at whether whether it was appropriate to deny the Muslim community from the right to rely on Section 13A of the Birth Deaths Registration Act, because the majority judgment took the view that surnames do not subsist for the Malay Muslim community, and therefore you can't avail yourselves of the mechanism afforded by Section 13A. She adopted a different view and said that, look, there's something called a patronymic surname, a surname that doesn't pass on generationally, but just passes on from one father to the next. So when for Malay Muslim children, basically, the patronymic surname operates in such a way that you will have a bin of the father's name, and so on and so forth, even as you go down the generations. Yeah, and she took the view, because there is this concept of patronymic surnames, Section 13A can be relied upon to afford relief for Malay Muslim illegitimate children to essentially apply to the registrar and enable the child to be named with the bin of the father's name. Yeah, and certainly, as if we talk about all the other issues, for example, right to identity, best interest of the child, these are all very important values and very important concepts for a child growing up in a family unit.
Can I ask a very simple question? I mean, why wasn't this fought in the Sharia courts?
Well, we were just looking at the application of the Birth Deaths Registration Act, which is a civil act, and whether the registrar exercise his powers of that civil legislation in an appropriate manner. There is no Islamic law question as such in terms of how he should exercise his power, because if you look at Section 13A, it's very clear as to what he's supposed to do. It just requires a joint application by the mother and father. As long as the father says, I'm prepared to give my name, that's the end of the matter.
Right. And where does the case go from here, Nizam? What's next after the federal court?
Well, as I mentioned earlier, you see, in the course of judgment being delivered, one of the clarifications that the AG's chamber sought was whether they could maintain the remark, Section 13, in the remark column of the birth certificate. We found it quite troubling, certainly, that the court took the position that it was lawful for the registrar to make that remark. And certainly we intend to revisit that by way of a suitable review application, because we certainly can't see the basis or source of that power in the Act itself. So we'd like to know from the court, please clarify and let us know exactly where that basis to maintain the remark is coming from. That's I suppose, one starting point in terms of the review application. There's of course some other arguments that we intend to ventilate, but I think it's also worthwhile to note, as I said, Tuanku Johor has made a commandment as to the effect of the fatwa, and I think it's worthwhile to perhaps quote him exactly on this, in the sense that he said whatever that the fatwa may be previously, it cannot be enforced sehingga menzalimi anak tidak sataraf sekaligus mengaibkan mereka pada masa depan. So there is, I think, His Majesty was very concerned about the future of the child, the best interest of the child, and I think there may be some avenue even in terms of exploring how that can impact on future applications to the NRD.
The final minute we have, what do your clients or people like your clients do? You said they send their kids to Chinese schools, they might not have a second child, so on and so forth. What are the practical implications of this ruling for them?
I suppose we are still trying to work out exactly the full ramifications of the judgment. But as I said, there were two questions of law that was answered by the federal court, and effectively the score was 1-1. So I don't think there was a real clear winner in that sense. But moving forward for parents in this sort of a position, grappling with this issue, I think they shouldn't basically give up. I think we are on the right side of history. As I keep saying, the children are innocent. There's a beautiful qasidah in front of a maqam of this famous poet in Turkey, Rumi, and it basically says, "Come, yeah. Whatever you have done, this isn't a caravan of despair. I don't think our courts is a caravan of despair, and I think we should certainly strive to push this issue still further. I certainly think there's many things that can still be argued, and God willing, we'll get there.
Well
Great,
said.
wonderful.
Thank you so much for being on the show, Nizam. It's been a pleasure speaking with you today.
Thank you.
I'm Melissa Idris, with me Sharakuta. That's all the time we have on Consider This tonight. Thank you for watching, and good night.